kind of untouchable. Ashley Madison was a tough victim to feel sorry for, and not just, or even primarily, because their stated mission was to encourage infidelity, and their site slogan was, "Life is short, have an affair." The company had touted the security and privacy of its services so often and hyperbolically in the years leading up to the breach that it was hard not to feel that they should have done more to protect their users' data, or, at the very least, delete it when they said they would. In particular, then ALM CEO Noel Biderman, who resigned shortly after the breach, had made much of the site's security in admittedly vague but strongly reassuring terms. "We have done a really great job of making sure our data is kept secret," he told one magazine in an interview just months before the breach. In another interview, he alluded to custom-tailored Ashley Madison technology that helped keep customers' data private, saying, "The perfect affair is not just meeting someone, it's not being discovered. So we really had to build the technology to help create the discretion. Unlike other websites you encounter, we're closed." He made repeated references to the ability of his company's technology to provide users with the elusive perfect affair, saying of user activity on the site that every step is looked at as, how do we keep this private between you and this other person? How do we keep your photos under lock and key? Of course, Biderman's threat model for who might try to steal users' data was not geared toward intruders like the Impact team. Rather, he seemed more concerned with snooping spouses and the power of his technology to prevent them from spying on their cheating husbands and wives, telling a reporter for the Calgary Herald in January 2015, "It's not lipstick on our collars anymore getting us caught. It's digital lipstick. Voicemails you leave behind, text messages you leave behind. So I focus on that. The technology I've built, the photo masquerading, the anonymous billing, even the way my messaging works, the password protection, even to the nth degree." From a technical perspective, it's hard to know what any of this boasting actually meant in terms of the site's security. Indeed, the password protection to the nth degree and the digital photos kept under lock and key on a closed website sound, in retrospect, like exactly the kinds of meaningless security nonsense that someone with no technical understanding would come up with if he were just making things up to reassure customers. The site itself displayed no fewer than 3 security-specific icons, one of which designated the site as the winner of a fictitious Trusted Security Award, alongside a graphic of a gold medal. Beyond trumpeting the site's security in general, Biderman also spent considerable time promoting, in similarly hyperbolic and hand-wavy terms, the extra-secure Ghost Delete, also called Full Delete or Paid Delete, feature that allowed users to remove all of their data from the site for a fee of $19 and generated $1.7 million in revenue for ALM in 2014. Biderman said the service would make it like you were a ghost, like you were never here, because it allows you to recall every message or photo that you have ever shared, and we even blow it off our own servers, which, by the way, sit in a remote location, kind of untouchable. Here again were more hints that he had no idea what he was talking about when it came to security. The reference to blowing data off a server, as if that process involved some kind of physical explosion, and the misplaced pride in the geographic remoteness of the company's physical servers, as if that somehow made them more difficult to compromise, because would-be hackers would first have to hunt them down. Biderman's pre-breach statements about Ashley Madison's security were significant, not just because they hinted at the company's general cluelessness when it came to security, but also because they would help provide the basis for customers and the Federal Trade Commission, FTC, to hold the company accountable after the breach occurred. Under Section 5 of the Federal Trade Commission Act, the FTC's purview for investigating and penalizing companies covers unfair and deceptive business practices, and the agency has at times struggled to figure out how exactly poor data protection practices fit into these designations and where to draw the line between fair and unfair security. But by over-promising on their security and lying outright about the paid delete function, Ashley Madison made it much easier for FTC investigators, as well as its customers, to allege deception and fraud, both of which are more clearly within the FTC's remit to police unfair and deceptive business practices than failing to protect customers' personal data. Beyond Biderman's boasts, advertisements for the site that claimed it was secure, anonymous, and risk-free were cited in the FTC's complaint as evidence of the company's deception, as was the site's privacy policy, which stated, "We use industry-standard practices and technologies including but not limited to firewalls, encrypted transmission via SSL, secure socket layer, and strong data encryption." While touting its untouchable servers, Ashley Madison's network was, in fact, regularly compromised during the months leading up to the Impact Team breach. Beginning in November 2014, investigators found evidence that intruders were able to log into the company's virtual private network, VPN, to remotely access the company's servers using shared credentials stored in documents on the ALM Google Drive. On 2 occasions, in May and June 2015, intruders used these stolen credentials to log into one of the site's payment processors, but the company did not notice any anomalous activity until July 12, 2015, when a large file was transferred from one of its databases to another. That same day, the Impact Team's first warning message appeared on the screens of employee computers at the ALM offices in Canada, accompanied by the AC/DC rock song Thunderstruck. In the message, the intruders threatened to release a huge cache of stolen data unless the company shut down its Ashley Madison and Established Men websites. The company hired the security firm Cycura to investigate, but did not make any public statement about the incident until a week later, after the Impact Team made its first online public leaks on July 19, releasing information about just 2 of the site's customers, a man from Mississauga, Canada, and another from Brockton, Massachusetts. The next day, ALM issued a press release about the breach and went to the Toronto police for help with their internal investigation. 1 month later, on August 18, 2015, the Impact Team made its first major release of the stolen data in a paste bin post containing 9.7 gigabytes of user profile and payment information. Included in the stolen information was data about several customers who had previously purchased the Ashley Madison paid delete service and been assured that their user profiles had been blown off the ALM servers in exchange for the $19 fee. Later releases by the Impact Team on August 20 and 23 contained lists of user accounts organized by employer and state, as well as users' sign-up dates, the amount they had spent on Ashley Madison's services, the IP addresses they used to access the site, and 19 gigabytes of internal company emails and source code for the Ashley Madison website. The source code leaks were hardly the most salacious bits of leaked data, but they gave outside security researchers the opportunity to vet the company's software security more thoroughly in the wake of the breach. One London-based security consultant, Gabor Satmari, found that the site's coders had hard-coded several passwords and other credentials into the site's source code. This meant that passwords and login credentials for Amazon Web Services and digital certificate private keys had all been typed directly into the website's source code in plain text, making it easy for anyone who got access to that code to also access the company's other accounts and authenticate to other parts of its network so they could find and exfiltrate additional data more easily. Furthermore, hard-coding credentials in source code would have made it more difficult for the company to update or change those credentials, since any such changes would have required editing the site's source code. And, as Satmari pointed out, many of the hard-coded passwords found in the source code were also relatively short, between 5 and 8 characters long, and could easily have been guessed using a dictionary attack. The vulnerabilities that enabled the Impact team to access ALM's network and move laterally across it to access so much user and company information were largely due to carelessness. Poorly chosen passwords, credentials stored in shared Google documents and embedded in website source code, few audits, and minimal monitoring of network activity. There was no evidence of the custom-designed privacy-protecting technologies Biderman had boasted of building, nor does there seem to have been much attention given to the potential for breaches and data theft, a surprising oversight in light of how often the company harped on its security and the responses to a leaked internal memo about ALM executives' top priorities. In the internal self-assessment memo, Biderman, as well as ALM Chief Technology Officer Trevor Sykes and Vice President for Operations Kevin McCall, all cited the importance of security. One of the questions in the self-assessment was, "In what area would you hate to see something go wrong?" To this query, Biderman responded, "Data exfiltration, confidentiality of the data." Sykes said, "I would hate to see our systems hacked, and/or the leak of personal information." And McCall commented, "There's a lack of security awareness across the organization." But whatever awareness or concern there may have been on the part of the company's management about the potential for a breach, very little of that translated into ALM's technical operations and decisions, almost all of which seemed to favor convenience and speed over security, undermining to a large extent the measures that ALM did have in place to protect its users' data. Password protection, even to the nth degree. Much of the data stolen from Ashley Madison was released in plain text, suggesting it had been stored unencrypted on the company's servers. But, to the company's credit, the passwords belonging to its users had in fact been encrypted using an algorithm called bcrypt. The bcrypt algorithm was strong enough so that password cracking tools would not have been able to decrypt the user passwords for a period of centuries running on modern computers. For the millions of users whose names, emails, and addresses had been revealed, it was most likely a small comfort, but still, it at least lent some credence to Biderman's claims about password protection and security. And while the victims may not have cared much by then whether their Ashley Madison profiles were compromised, the encryption probably helped protect any accounts they may have had on other sites that shared the same passwords. Then, in September 2015, a group of recreational password crackers studying the Ashley Madison site source code discovered something unusual about the way the site encrypted user passwords. In the same database as the bcrypt encrypted passwords, millions of those passwords had also been hashed using a different algorithm called MD5. MD5 essentially translates a password into a number, called a hash, that can be used to quickly check an attempted login without storing the password in plain text. So when a user entered their password into the Ashley Madison site, the site would hash whatever text they entered using MD5, and then compare the result to the hash number they had stored for that user to see if the password was correct. MD5 does the same thing bcrypt does, turn a password into a number that's not the password itself, but in a much simpler manner that requires much less computation to undo than bcrypt. If ALM had hashed all of the bcrypt encrypted passwords with MD5, that wouldn't have mattered. Anyone who cracked the MD5 hashes would still have been left with a relatively useless encrypted password. But for many of the stored passwords, ALM didn't apply MD5 to the encrypted passwords. Instead, the company first encrypted a plain text password with bcrypt. Then they combined the plain text password with the associated username, inserting 2 colons between the username and password, changed all the letters to lowercase, and then hashed the entire combined lowercase phrase containing both username and password with MD5. Those MD5 hashes were then stored in the same database as the encrypted passwords, possibly to allow users to log in without having to enter their passwords every time. For instance, for someone with the username user and the password secret, both would be converted to lowercase and then concatenated with 2 colons separating the username and password. The combined string of user : secret would then be hashed using MD5 and could then be cracked to determine that the user's password was some version of the word secret that could be determined from testing each possible combination of capital letters in the word to find one that matched the bcrypt encrypted version of the user's password, which was also stored in the site's database. More than 15 million user passwords were stored in both forms, encrypted with bcrypt and hashed with MD5, and most of those in the latter format could be guessed quite easily by generating passwords, adding them onto the username with 2 colons, and then taking the MD5 hash to see if it matched the entry stored in ALM's database. Because MD5 hashing, unlike bcrypt encryption, is so fast, it was possible to test billions of guesses per second this way, and guessing passwords in this manner allowed the hobbyist crackers to figure out more than 11.2 million of the leaked passwords within only a month of the data's release. What made the aftermath of the Ashley Madison breach so unusual and so bitter, besides the sensitive nature and personal consequences of the stolen information, was not ALM's security or lack thereof, but rather that ALM had so boastfully exaggerated its extraordinary security measures beforehand. In subsequent complaints filed about the incident, both Ashley Madison customers and the FTC emphasized the ways in which the company had aggressively overpromised and outright lied to users repeatedly about how well protected their data was and how much control they had over it. In both cases, their strategy was precisely that prescribed by the Impact team. Accuse ALM of lying to their customers about their site's security and paid delete service in order to shift liability for the consequences of the breach onto the company. It was a strategy that made sense, since there is a much clearer legal way, particularly for the FTC, to punish companies for engaging in deceptive business practices than there is to punish them for failing to protect customer data from being stolen. This is especially true when the harm inflicted by that theft is largely emotional, psychological, and personal, rather than financial, and therefore offers fewer opportunities for legal remedies. At the same time, it was a case that highlighted, yet again, the ambiguity surrounding what a company's obligations are when it comes to securing customer data, particularly if the company doesn't make false promises about the quality of their security. If A.L.M. was at fault primarily because they had overpromised and underdelivered when it came to security, then what did that mean for companies that never promised their customers any kind of security? Could they be breached with impunity, and then insist that they had never deceived anyone by pretending to have good security? Or was there some baseline level of security that firms owed their customers by default, in the name of fairness? At the time of the Ashley Madison breach, the FTC was fighting out precisely that question with Wyndham, the hotel chain that suffered 3 breaches in a span of 2 years, but contended it had done nothing deceptive or unfair in failing to protect its customers' data. When it came to investigating A.L.M., the FTC stuck to more familiar and certain ground for the agency, arguing that the company had deceived its customers, not just with an ineffective paid delete service, but also by creating profiles for fake female users that tricked customers into believing they were meeting women on the site, causing them to spend more money on the credits used for sending messages to other profiles. The Engager profiles. When the Impact team first released the Ashley Madison accounts data, it cautioned in the message that accompanied the posting, "Keep in mind, the site is a scam with thousands of fake female profiles." They referenced a lawsuit filed in 2012 by a former A.L.M. employee, Doriana Silva, who alleged that the company had her create up to 1,000 fake profiles for women on Ashley Madison, causing her to develop a repetitive strain injury in her wrist. The stolen information about millions of Ashley Madison users provided an opportunity for reporters to investigate that suit's claim that the site was riddled with fake profiles for women that encourage men to spend more money subscribing to the site. In order to initiate conversations with other users, customers had to purchase credits through the site. Annalee Newitz, writing for Gizmodo in August 2015, identified 70,572 accounts created by Ashley Madison to engage other users. 70,529 of those Engager profiles were female, and many were linked to @ashleymadison.com email addresses or accessed the site from IP addresses associated with the A.L.M. offices. Since these bots kept detailed logs of how often they contacted other users and whom they contacted, Newitz was able to figure out that 20 million of the site's 31 million male users had received messages from the Engagers, as well as the list of messages they were programmed to send. Their initial messages were mostly variations on the theme of "Hi" and "Hey there," but further into a conversation they were given longer snippets of dialogue, including, "When I was younger, I used to sleep with my friends' boyfriends. I guess old habits die hard, although I could never sleep with their husbands." And, "I'm sexy, discreet, and always up for kinky chat. Would also meet up in person if we get to know each other, and think there might be a good connection. Does this sound intriguing?" Although the creation of automated Engager accounts was unrelated to issues of data security, Ashley Madison customers and the FTC seized on the evidence provided by the stolen information to pursue charges that A.L.M. had deceived its customers into spending money on conversations with bots. The FTC pointed out in its complaint that when new users joined the site, They were greeted with a welcome message that promised, "We have thousands of women in your city who are in the exact same situation as you and looking to have a discreet affair," and that the site used photos of existing members who had not been active in recent years to create these fake accounts. Because users had no way of knowing whether or not the women messaging them on the site were real or fake, unless they could tell from the quality of the bot's pre-programmed conversation snippets, many of the real users were induced to upgrade to full memberships so that they could send emails and engage in online real-time chats with these fake profiles, the FTC concluded. The same complaint was leveled by several Ashley Madison customers in a series of lawsuits filed in 2015 and later consolidated into a single class action suit. David Yeagle of Colorado, for instance, said in the suit that he spent at least $850 on credits for the site to send messages as a result of defendants' female profiles, which were in fact fraudulent bots created by defendants rather than actual users of the website. Paul Jack of North Carolina reported a similar experience while spending roughly $1,500 on Ashley Madison credits. Despite the fact that ALM mentioned automated angel accounts used for marketing research in its terms of service agreement, the FTC accused them of falsely implying that messages received by members were from actual women, and the plaintiffs in the class action suit alleged they would never have signed up for the site or purchased credits had they known that so many of the women they met on it would be fictitious. In this case, as with the paid delete function, it was not so much what ALM did that got them in legal trouble. It's not illegal to build chatbots or even to charge people to chat with them, but how they had misrepresented it to their customers. Damages. Misrepresentation, then, was the crux of the class action suit brought against ALM, as well as the FTC investigation. Not just that the site had failed to protect its customers' data, but that it had egregiously misled customers about the steps it had taken, or claimed to have taken, related to data security, deletion, and the creation of fake accounts. But while the company's deceptions might have offered the clearest legal recourse, the real harms at the root of Ashley Madison's customers' grievances were much more personal and emotional than money wasted on a futile paid delete service or on credits to chat with fictitious bot women. The class action complaint states, "The fact that this information has been made public has caused and will continue to cause irreparable harm, including public humiliation, ridicule, divorce, extortion, loss of employment, and increased substantial risk of identity theft and other types of fraud, among other catastrophic personal and professional harm." The intensely personal nature of the consequences of the breach for many Ashley Madison customers led to them demanding impossibly high damages in their initial lawsuits. In just the first month following the breach, the lawsuits filed against ALM claimed, in total, more than $1 billion in damages. But these were exactly the types of harm that lawsuits had proven least effective at compensating victims for in the wake of data breaches. Most of the types of harm alleged by Ashley Madison's customers had no clear-cut physical or financial toll for which ALM could be held liable. Looked at in a certain light, the victims could even be said to have brought many of the personal consequences of the breach on themselves, simply by signing up for the website. Though Ashley Madison undoubtedly played a crucial role in outing their activities through its poor security practices and empty promises of total deletion. Even the potential consequences that did have a clear financial cost, such as identity theft and extortion, were mostly examples of the kinds of speculative future harm that courts had been skeptical of in prior cases. So it was no great surprise that the ultimate settlement for the U.S. class action lawsuit, agreed to in July 2017, came to just over $11 million. Individuals affected by the breach were permitted to claim up to $3,500 of that money each to cover documented losses stemming from the breach. Meanwhile, the FTC, which had initially sought a penalty of $17.5 million for the company's misrepresentation of its user accounts, paid delete service, and inadequate security measures, ultimately agreed in November 2016 to a $1.6 million settlement. In addition to the financial penalty, the company agreed as part of its settlement with the FTC to implement a comprehensive data security program and permit assessments of that program by a third-party auditor. What, exactly, this new security program would look like was left up to the company itself, which offered few hints about how it planned to revamp its security measures in the wake of the breach. In fact, beyond pursuing legal settlements, the only clear public efforts ALM made to try to contain the impacts of the breach were legal, not technical, and drawn directly from the Sony Pictures playbook. In August 2015, ALM took advantage of the takedown notice regimes implemented by many websites to comply with the Digital Millennium Copyright Act, DMCA, and used these systems to report posts that discussed or showed screenshots of their stolen data as copyright violations. Avid owns all intellectual property in the data, which has been stolen from our data center and disclosed in this unauthorized and unlawful manner, the company wrote in one complaint, filed with Twitter over a reporter's posts of internal spreadsheets on which all financial information had been redacted prior to posting. The DMCA was a blunt instrument for this purpose. It stipulates that websites that post user content must take down any infringing content on their sites shortly after they are made aware of it. Otherwise, the site itself can be held liable for infringing material that other people post to it. In practice, many sites have notice and takedown reporting tools for users to flag potentially infringing content in order to claim this legal immunity for infringement. Internal company spreadsheets or email excerpts are hardly the types of content the DMCA was designed to protect. Per the Constitution, copyright laws are intended to promote the progress of science and useful arts by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. And it's hard to see how protecting Ashley Madison's internal files could conceivably promote science or any useful art. Still, some sites simply remove all such flagged posts rather than go to the trouble of determining which ones actually constitute infringement. ALM's complaints, like Sony Pictures' efforts, succeeded in getting a few tweets blocked, but did little to stem the spread of news of the breach overall. The company's largely, though not entirely, unsuccessful attempt to twist a copyright law into serving as a tool for preventing people from discussing the company's publicly available stolen data was yet another reminder of how few options are available for ex-post mitigation when it comes to containing the damage of breaches motivated by a desire to publicly shame victims, and how closely some of those options resemble censorship. For ALM, the costs incurred by the 2015 breach were not trivial. By some estimates, between legal fees, settlements, and new security investments, the incident cost the company more than 1/4 of its annual revenue. But neither did the breach put ALM out of business, as the impact team seems to have hoped it would. and ALM went to great lengths to ensure that the legal proceedings would be every bit as costly and personally distressing to the individual plaintiffs as they were to the company itself, successfully persuading a judge that any plaintiffs who joined the case should be compelled to use their real names rather than hiding behind pseudonyms. Anonymous John Does had filed most of the early suits against ALM, but after many of those suits were consolidated into a single class action case in Missouri, Judge John Ross ruled in April 2016 that plaintiffs who wished to proceed with the suit would have to provide their real names. The plaintiffs argued that revealing their names could expose them to the threat of personal humiliation as well as extortion, but ALM countered that its customers' sexual preferences and habits do not constitute information of the utmost intimacy so as to require anonymity. In his ruling, Ross at first appears to sympathize with the plaintiff's wish to remain anonymous, writing that the possible injury to plaintiffs rises above the level of mere embarrassment or harm to reputation, and conceding that perhaps the injury litigated against would be incurred as a result of the disclosure of the plaintiff's identity. In other words, by bringing a public lawsuit against ALM with their real names attached to it, the Ashley Madison customers suing the company might only serve to worsen the humiliation and consequences of the data breach that had caused them to bring the suit in the first place. But ultimately, Ross decided those considerations were outweighed by the fact that this was a class action, where a plaintiff seeks to represent a class of consumers who have a personal stake in the case and a heightened interest in knowing who purports to represent their interests in the litigation. For a group whose information had already been published all over the Internet, it was at once a small additional humiliation and a significant reminder that their names and reputations would forever be tied to this one incident and website. Because the plaintiffs in the class action suit were in part trying to allege that ALM had been negligent in its failure to protect their personal data, they emphasized that the company's security practices were in violation of accepted industry practices and FTC guidelines. The complaint stated that Ashley Madison failed to meet the Payment Card Industry Data Security Standards, PCI DSS, the same industry set standards that the payment card companies sued TJX for failing to meet after its own breach a decade earlier. Were that indeed the case, it would have been a matter for ALM to settle with the credit card companies and banks with whom it had agreed to adhere to PCI DSS, not with its customers with whom it had no such agreement. But this breach, unlike the financially motivated TJX breach, apparently resulted in too little financial fraud for the payment industry to get involved. The class action complaint also invoked ALM's failure to meet the entirely voluntary Department of Homeland Security's Fair Information Practice Principles, or FIPS, which provide organizations with broad recommendations for protecting information, such as offering users choice about how to control their data and ensuring that data's integrity and security. It is not surprising that, in alleging negligence, the plaintiffs tried to establish a set of accepted industry practices based on the PCI DSS and DHS FIPS that ALM failed to implement. But their complaint often goes too far in trying to justify the importance and effectiveness of these types of standards. For instance, the plaintiffs allege that, had defendants complied with the PCI DSS and other basic industry standards governing data security, the Ashley Madison data breach could not have occurred. This is an especially strange assertion to make, given that PCI DSS standards pertain only to the protection of payment data and would have done little to stop the theft of the many other types of data stolen from ALM's network. Adultery aside, what's most startling and perhaps most depressing about the Ashley Madison complaint is how closely it resembles the lawsuits filed in the aftermath of incidents such as the TJX breach, the SCDOR breach, and the OPM breach, which were perpetrated for very different reasons and had very different consequences. Since there was no clear legal pathway for trying to redress the very particular and personal damage that the victims of the Ashley Madison breach suffered, they had to try to turn their case into one centered on monetary losses and PCI DSS compliance, even though the financial component was, for many of them, only a tiny piece of the harm caused by this incident. The Ashley Madison breach pitted a company against its customers and attempted to put price tags on the highly subjective impacts of non-financially motivated breaches that take their toll primarily in broken marriages, public humiliation, and other personal tragedies with no obvious dollar equivalent. There is no clear legal path to dividing, settling, and assigning blame for these types of costs, and so instead, the victims were forced to resort to the familiar legal templates carved out by payment card breaches, as if every data breach were just like any other, and all data equivalent in its sensitivity and capacity to cause harm that was above all else financial in nature. The Spamhaus, Sony Pictures, and Ashley Madison incidents do not align neatly with as coherent a unifying motivation as financial profit or espionage. In all three cases, the perpetrators were driven by some desire to exact revenge on the company in question through some form of large-scale public-facing humiliation, but that revenge and humiliation manifested in very different ways. The Stophouse team wanted to shut down Spamhaus's operations and drive away their customers. The Sony Pictures intruders wanted to prevent the release of a movie and humiliate everyone who was in any way involved or associated with it. And the Ashley Madison breach was ostensibly intended to shed light on the site's inadequate security practices and mobilize users against ALM and its overblown security promises. What these incidents have in common, and the reason they are grouped together in this section, is that their perpetrators gained very little from them in terms of money or secrets, while their victims' losses were, similarly, profoundly intangible and often quite personal. Both of these features have important implications for defense, mitigation, and remediation. The fact that the perpetrators had no later-stage plans to monetize or act on the information they stole meant that even more than in espionage cases, there were very few opportunities for intervention once a target's technical lines of defense had failed. For the individual victims whose information was released, it also meant that the traditional tools that helped insulate people from the costs of data breaches, laws requiring credit card companies to cover fraudulent charges, for instance, or credit freezes, or identity monitoring services, were largely useless. This was true to a lesser extent for espionage incidents, including the DigiNotar compromise, the PLA Unit 61398 campaign, and the OPM breach. But in those cases, the damage inflicted on individuals seemed, for the most part, to be less personal and less immediate, or at the very least, less public. Moreover, state-engineered espionage efforts seemed like something for other governments to address, as the U.S. government indeed tried to do in a variety of different ways, ranging from trade restrictions to indictments to personnel reassignments. Similarly, the risks posed by espionage, whether economic, political, or both, seemed aimed at entire countries rather than at particular individuals. Even in the case of the DigiNotar compromise, which may have directly affected the lives of individuals in Iran, there are no clear examples of people who had their personal and professional lives decimated in the same way that some victims of the Sony Pictures and Ashley Madison breaches did. And yet, even when there were clear-cut examples of the serious long-term harm that a data breach like Sony Pictures or Ashley Madison had caused, there was still no meaningful legal path to remedying that harm or holding the responsible parties accountable. Breaches intended to wreak general havoc and humiliate a particular targeted party are not necessarily worse or even more damaging than espionage incidents or financial crimes. But they are harder to defend against at every level, from the targeted organizations on down to the individuals involved, because they inflict harms so intangible, so specific to individuals, and so difficult to quantify, that they are all but unrecognizable for the purposes of existing legal and policy remedies. Operation Stophouse provides an interesting counterpoint to this problem, given its relative lack of success in inflicting any long-term harm on either Spamhaus or anyone else affiliated with the company. The Spamhaus incident suggests that with sufficient cooperation from the infrastructural stakeholders across the Internet, and in the absence of harm directed at individual people, it may in fact be possible to effectively mitigate security threats perpetrated for no purpose beyond a desire for revenge. The relatively rapid and effective response to the Stophouse DDoS attacks has implications that extend to espionage and financially motivated incidents as well. It highlights not just how important it is to have an array of online stakeholders coordinating defensive efforts, but also how much more complicated the harms inflicted by cybersecurity incidents become when they extend to individuals, not just organizations. Incidents that impose not just financial costs on their victims, but also take personal, psychological, and professional tolls, often cannot be meaningfully addressed through existing legal pathways, leaving victims with token settlements and little recourse. Incidents intended to humiliate their targets, rather than simply rob them, impose an additional burden on victims, even beyond the harm directly inflicted by the breach itself. The burden of trying to make others recognize and acknowledge that harm and how much it has cost them, despite the fact that no one stood to benefit. Part 4. Who should safeguard our data? Distributing responsibility and liability. 11. Email the way it should be. The role of application designers and software developers. Defensive lessons derived from past cybersecurity incidents are sometimes criticized for only helping people protect themselves against yesterday's attack methods instead of the innovative, never-before-seen, cutting-edge attacks likely to be leveled at them in the future. This is a valid concern to some extent. Focusing too much on the technical mechanisms used to compromise computer systems in the past could potentially blind a defender to other newer techniques, but it's often overstated, especially when it comes to less technical lines of defense that revolve around economic, policy, and legal changes. Cybersecurity incidents and the modes of compromise employed by their perpetrators evolve less rapidly than this argument implies. None of the security incidents presented in the previous chapters are identical, but many share some common stages and techniques, including phishing, theft of authentication credentials, use of bots, and exfiltration of large compressed files. And in the immediate aftermath of many breaches, Almost regardless of how or why they were perpetrated, people routinely fault targeted organizations for failing to implement the same two technical controls: multi-factor authentication and encryption. That same criticism has been leveled at the South Carolina Department of Revenue, the Office of Personnel Management, Sony Pictures, and Ashley Madison, all of whom suffered very different breaches at the hands of very different intruders, motivated by very different goals, across a span of several years. Intruders can and do come up with entirely novel means of compromising the computers they target, but more often they rely on at least some of the same techniques that have worked so well for others before them. More importantly, the technical mechanics of breaches are far from the most significant or critical causes of cybersecurity incidents and their resulting harms. The most important lesson that emerges from revisiting major cybersecurity incidents of the past decade is not that everyone would be secure if they would only use multi-factor authentication and encryption. Quite the opposite, in fact. To believe that the success of a breach hinges on one or two specific technical decisions made by an individual or an organization is fundamentally to misunderstand the complicated and cooperative work of defending computer networks and systems. The history of computer security breaches demonstrates over and over again that there are a variety of different stakeholders involved in defending computer systems, each of whom has an important defensive role to play, and each of whom is far more likely to devote significant time and energy to shifting that defensive responsibility onto someone else than to shouldering it themselves. Making progress on defending computer systems therefore requires a clearer picture of who is responsible for doing what, a clearer set of incentives for all of the stakeholders involved to assume the defensive roles they are best suited to, and penalties and legal consequences for those who fail to do so. The final section of this book considers the defensive responsibilities that can best be undertaken, or, in some cases, only be undertaken, by three groups of stakeholders: application designers, organizations, and policymakers. These categories are by no means exhaustive. There are several other stakeholder groups and subgroups, such as individual users, Internet service providers, and online payment processors, who can exercise vital defensive capabilities when it comes to mitigating and preventing computer intrusions. But these three broad distinctions provide a useful starting point for trying to envision what it might mean to design a defensive ecosystem that plays to the particular strengths and unique capabilities of the many different people, companies, and groups who interact and overlap online. Security practitioners often talk about how there is no single silver bullet for computer security, no one security tool or control to solve all problems and neutralize all threats. A corollary to that maxim, perhaps, is that there is no single bulletproof defender who can unilaterally prevent all compromises and detect every breach. Having visibility into and control over the different stages of computer-based threats requires the skill sets and capabilities of a wide range of different defenders, from individual users to service providers, content providers, system administrators, payment processors, software developers, and even policymakers. In a world of increasingly networked computers, a breach of one organization's computer systems often occurs only after several different stakeholders, not just the organization whose data was stolen, have missed opportunities to interrupt the intrusion or put in place stronger defenses. The interconnectedness and interdependence among these different stakeholders and their computer systems contributes to the difficulty of sorting out who should be responsible for protecting those systems, and means that, ultimately, there is always someone else for any individual stakeholder to blame for a breach besides themselves. The failure to foster better defensive cooperation and coordination among those stakeholders, or even to recognize the importance of broadening the defensive landscape beyond individual breached organizations, is the dominant recurring theme of the major cybersecurity incidents of the past decade. It's the story of the payment networks, banks, and retailers turning on each other in the aftermath of the TJX breach. The story of the SCDOR handing off blame for its breach to the IRS, who in turn passed the buck to NIST. The story of Internet service providers looking the other way while Bogachev built up his game-over Zeus bot, and cryptocurrency exchanges around the world blithely cashing out the Bitcoin payments made by the victims of CryptoLocker. It's the story, too, of browser manufacturers and certificate authorities scrambling to figure out how to trust each other, but also place checks on that trust in the aftermath of the DigiNotar compromise. The story of the PLA Unit 61398 compromising computers on U.S. college campuses in order to infiltrate U.S. companies. The story of OPM ignoring security audit after security audit, only to blame their breach on third-party contractors, and overly restrictive OBM-issued guidelines. And it's also the story of Spamhaus partnering with Cloudflare and rallying its network of online service providers to overcome the Stophouse DDoS attacks. The story of Sony Pictures failing to notice when its data was being stolen and deleted, and then going after the journalists who reported on that stolen data. And the story of Ashley Madison users turning on a company that had so often boasted of its incredible security and whose breach had cost them so much, only to learn that in order to pursue any attempts to hold the company responsible for their loss of privacy, they would have to submit to yet another embarrassing public ordeal by revealing their own names. In many of these incidents, the central conflict between the victims and the perpetrators was quickly overshadowed by the conflicts and infighting that emerged between the various victims and other stakeholders. There are many ways that individuals, organizations, and governments can strengthen computer security, from using stronger encryption algorithms to passing new legislation, and this book is not intended to be a comprehensive catalog of them. In particular, there is a vast array of technical tools and techniques that are not covered here. Instead, this section focuses on solutions that can enable greater collaboration and cooperation between different stakeholders who can help defend against and mitigate future cybersecurity incidents, as well as ways to clarify the respective roles and responsibilities of those stakeholders and incentivize them to assume defensive postures that may be as much about protecting others as they are about protecting themselves. Application design as defense. Long before a company like TJX or Sony Pictures or a government agency like SCDOR or OPM makes any decisions about how to secure its data and networks, a host of design decisions are made about the software programs, technical protocols, and online services they rely on, and what types of behavior those applications will and won't permit. These decisions by application designers and software developers have tremendous security consequences, even beyond developers' traditional security roles of finding and fixing technical bugs and code vulnerabilities. Bugs and vulnerabilities allow intruders to do things using an application that the application designers did not intend users to be able to do. But equally important are the deliberate decisions those designers make about what constitutes legitimate behavior, the behaviors that developers do intend for users to be able to exhibit in the context of their particular applications. Those limitations are important because one of the hardest elements of defending computer systems is recognizing that something unusual or illicit is happening in the context of that system. And while those distinctions between allowable and illegitimate activity in the context of an application often manifest as technical controls, they stem from what are essentially policy decisions made by application designers about what people should and should not be allowed to do using their applications, in much the same way that regulators make decisions enshrined in law rather than code about what people and companies should and should not be allowed to do with computers. The individual technical stages that comprise the early stages of cybersecurity incidents are often indistinguishable from the normal everyday legitimate uses of computers. For instance, these stages may involve the perpetrators doing things like connecting to servers and wireless networks, sending and receiving email messages, logging into accounts, sending and receiving files, and downloading and executing software. Gonzalez and his co-conspirators initiated the TJX breach by joining the Marshall's wireless network. The perpetrator of the DigiNotar compromise started out by connecting to the company's public web servers. PLA Unit 61398 officers commenced their espionage efforts by sending emails to U.S. companies. The Stophouse Group launched their DDoS attack by directing DNS queries at Spamhaus. All of these are activities that might be perfectly reasonable to allow, that are in fact entirely permissible when some people do them, but not when other people do them. And yet, one of the most basic and fundamental assumptions underlying any attempt to defend computer systems is that malicious and legitimate uses of these systems are, at some point, in some way, different, and therefore possible to profile or identify using various security controls and network monitoring techniques. There has to be some indicator of malicious activity that defenders can look for, or block, or monitor, some way of distinguishing the good guys from the bad guys, even when they're doing almost identical things. The hardest stages of threats to defend against are the ones that most closely resemble legitimate use by legitimate users. In the aftermath of these breaches, there is often disagreement about who was responsible for noticing early indicators of maliciousness, or best poised to constrain attackers' ability to masquerade as legitimate. For instance, in the case of the South Carolina Department of Revenue breach, at what point should someone have noticed the intruder? When the phishing emails first arrived? When the phished credentials were used for remote access? When large amounts of data were packaged in archive files? When those files were exfiltrated from the SCDOR network? Each of those stages was, for a while at least, indistinguishable to the agency from the activity of legitimate SCDOR users on the department's computer systems who were receiving emails, logging in remotely, or accessing and moving data. This was partly a failure on the part of the SCDOR to do more aggressive monitoring, but it was also partly a failure on the part of the people who designed their software and systems, who could have made it easier for the department to distinguish between legitimate and malicious activity. The SCDOR employees who opened phishing emails bear some responsibility for failing to notice that those messages were not from their purported senders. But so, too, do the people who designed email to make it possible for anyone to send an email message from any email address. That's not a bug in email. It's a deliberate design decision, one that makes life a little easier for phishers and a little harder for every individual and organization that uses email. Organizations have considerable control and autonomy when it comes to protecting their networks, but they are also constrained in many ways by the applications they use, including email, web content management programs, and messaging services. Those constraints are most apparent in the distinctions that application designers and their applications make between malicious and legitimate activity, and how difficult it is for users to disguise the former as the latter. Application designers' decisions about what types of behavior to allow and disallow for users often lay the groundwork for how intruders will attempt to infiltrate a protected system by disguising their initial steps as legitimate activity within the permitted bounds of a particular application. Those boundaries put in place by application designers help dictate how attackers initiate intrusions, how organizations using their applications monitor and define malicious behavior, and they have even been invoked by courts as the grounds for determining what is and is not considered illegal hacking. The first person convicted of illegal computer hacking under the U.S. Computer Fraud and Abuse Act, CFAA, was Robert Morris, then a graduate student in computer science at Cornell, who in 1988 released a computer worm that replicated itself by exploiting software vulnerabilities, including bugs in an email program and a directory service. Since no one else had ever been convicted under the CFAA of accessing a computer without authorization, and since the text of the law itself offers no definitions of either access or authorization, there was some uncertainty about whether Morris's behavior clearly fit that description. His lawyers, naturally enough, argued that it did not. Because he was a Cornell student, they argued, he was authorized to use the Cornell computers, as well as the computers at MIT where he first released the worm, since they were connected to Cornell's via the Internet. The ruling, incidentally, was the first court decision in the United States to refer to the Internet. But the final ruling on the Morris case, issued by the Second Circuit Court of Appeals in 1991, determined that authorization to access computers did not derive from the university that owned and operated them, but rather from the application designers who had programmed their software. Judge John Newman wrote in the ruling, "Morris did not use either of those features, the email and directory applications, in any way related to their intended function. He did not send or read mail, nor discover information about other users. Instead, he found holes in both programs that permitted him a special and unauthorized access route into other computers." In other words, what made Morris's worm unauthorized, and therefore illegal in Newman's view, was not that Morris didn't have permission to release it from the people who owned and operated the computers he used, but rather that he didn't have permission from the people who designed the email and directory programs to use their applications in the way he did. By exploiting bugs in the email and directory programs to propagate his worm, Morris used those programs in a way other than their designers presumably intended them to be used, and in doing so, broke the law. This is a remarkable amount of power to give application designers, to say that people who use their code for anything other than its intended function have illegally accessed a computer without authorization essentially means that application designers get to decide what is legal and what is illegal to do with computers based on how they intend users to use their programs. The designers themselves had created the bugs that Morris exploited, but that was not their fault, according to the court's interpretation, because they had not meant for anyone to use their programs the way Morris did. Yet, if the application designers have the power to determine what constitutes acceptable and even legal use of their programs, they are rarely held responsible when those decisions lead to bad outcomes. In fact, the CFAA The very same law that Newman interpreted as giving application designers the power to decide how people are authorized to use computer code explicitly forbids suing anyone for negligent design or manufacture of computer hardware, computer software, or firmware. This immunity for the hardware and software industries is often blamed for enabling coders and companies to put out buggy or vulnerable code without fear of legal consequences. But its implications go beyond just absolving developers for making coding mistakes. After all, application designers' role in defending computer systems is more than just catching errors, and the framework put in place in the CFAA to shield them from charges of negligence in some sense also distances and shields them from the consequences of the design decisions they make about what constitutes legitimate user behavior. Increasing work and sending signals. The crucial contribution of application designers to protecting computer systems is making it as difficult as possible for intruders to masquerade as legitimate users. There are two general ways application designers can do this. One is to make it harder for all users to do things that could be used for malicious purposes, like sending attachments and links via email. And the other is to offer clues to legitimate users, administrators, or other potential defenders to help them detect potential malicious activity. Both of these models of defense require the application designer to be able to distinguish between what types of capabilities, in the context of a particular application, are most likely to be linked to something illicit or malicious. Assuming that those capabilities also have some legitimate purposes, as indeed emailed attachments and website links do, it may not make sense for the designer to ban them outright. Instead, a designer might choose to increase the amount of work required of users for them to be able to exercise those capabilities, making it a slower or more resource-intensive process for attackers, by forcing them to acquire some additional credentials or reputation. Examples of this include payment processing sites like PayPal that limit users' access to funds until after they have had their accounts for a certain period of time, or review sites like Yelp that demote or hide reviews published by brand new accounts. Both of these restrictions make it a little harder for a user to make off with funds from a fraudulent transaction or write an unwarranted disparaging review of a competitor. The malicious acts are still possible, but they require a bit more work. For example, a few weeks invested in building the reputation of an online account or writing other reviews. Ideally, forcing users to earn the right to exercise these capabilities can contribute directly to the signaling process. If the work needed to acquire potentially malicious capabilities itself serves as a signal to legitimate users. Both PayPal and Yelp are examples of applications in which users have credentials, a login username and password, that is, through which their capabilities can be restricted and adjusted according to their actions. Often, however, cybersecurity incidents are initiated using applications that enable online interaction between strangers and therefore require no vetted credentials. The TJX breach, SCDOR breach, DigiNotar compromise, Unit 61398 espionage, and the OPM breach all involved intruders who leveraged email and websites that required no authentication to steal credentials that then enabled further compromises. For an application like email that is not operated by a single centralized entity and that regularly facilitates online communication between people who do not know each other, defenders are especially dependent on the clues afforded them by application designers to distinguish between malicious and legitimate interactions. The central challenge of application defense is identifying specific capabilities of particular applications that indicate or lend themselves to malicious behavior. The narrower an application's intended function is, the easier it tends to be to distinguish between malicious and legitimate use, because legitimate activity takes on a very specific and repeated form. Indeed, the value in focusing defensive interventions at the application layer is precisely application's specificity of function and use that makes it easier to pinpoint malicious indicators and ascribe intention to early access capabilities. More general pieces of software, such as operating systems or web browsers, are more difficult to defend because they offer less specific templates of what allowable behavior should look like. If the strength of application defenses lies in designers' ability to tailor definitions of malicious and legitimate activity to individual application functions, their weakness stems from the wide range of applications used by individual people and machines. Restricting or blocking off one capability in any individual application does not prevent intruders from using other capabilities or applications to achieve the same ultimate goal. So, application designers can, at best, hope to defend against malicious capabilities acquired through only one of many substitutable channels. In this regard, defense at the application layer closely corresponds to the proposed model in which attackers have the advantage over defenders, because the latter group has to protect everything, while the former only has to find one vulnerable point of entry. Many applications help users distinguish between who is a legitimate user and who is a malicious one, based on whether a user has a known, trusted set of credentials. This avoids the problem of figuring out whether the user's activity looks particularly malicious by simply trusting that the user is not malicious, based on their credentials. However, a few applications intentionally facilitate interaction with unknown users, or users who do not possess vetted credentials. Since these applications, which are accessible to unknown users, are often the starting point for acquiring credentials that grant further access, they offer an interesting set of challenges for defenders, decidedly different from those faced by designers of authentication-based applications.